Hi, everybody. Welcome today. It's cold out, but it's sunny, so we'll take it up here in New York. We're going to talk today about keeping your trust healthy. I'm going to start with a few of my standard disclaimers. One is none of this is meant to be legal advice to you. This is educational. I say that for a few reasons, the most important of which being it's really important that you get advice on your specific circumstance from your own advisors, because the things I'm going to talk about today may apply in whole or in part, or unlikely to apply in whole to any one person, but in part to everyone. And so the idea is to get you thinking about your documents if you already have them, or about the documents you might be looking to create, and then actually seeking that advice in your circumstance, because not everything we say here today will apply to you. So I'm going to start right off the bat with what is a trust. I had a client several years ago who said to me, I don't get it. What is the trust? Where does it live? What is it? And I told her, in her instance, she had created a trust and she had a bunch of bank accounts in it. And I said, I'm going to make you a box and I'm going to write trust on the box. And every time a statement comes in from one of your brokerage accounts or bank accounts that you've titled in the name of your trust, I want you to put those statements in the box, and that's going to be where your trust lives. Because it's a really hard thing for people to wrap their head around. You create a trust, but what is it, right? So it all starts with the document. You sign a document that is a trust agreement. I call it the rules of the game. It's explaining to you what you can and can't do, what your other trustees, if there's someone other than your selfish trustee, can or can't do. It explains your rights. It explains the rights of other beneficiaries, either while you are alive or after you die. And all of the rules should be laid out in the trust. So it all starts with that trust agreement, the document. It's really important. Number one, keep your trust healthy, is know where that document is. And if you've amended it or restated it, you've made changes to it along the way, know where those changes are too. Because if we can't find the document, we're often left knowing what the trust owns, but we don't know what we can do with it. And I'm going to give you an example. So we create the document and then we title things in the name of the document. So let's say we're putting somebody's home into a trust. Well, then if you have a deed, we sign a new deed where I, Britt Burner, give my house to the Britt Burner Trust. And so now the Britt Burner Trust owns my house. If I have a bank account, Britt Burner's name is on the bank statements, but now I'm going to change the ownership to be the Britt Burner Trust. Well, now my statements are going to come in the name of the Britt Burner Trust. And just like I told that client, if she needed a physical place where it was going to live, because some are with one bank and some are with another bank, and there's my house, I'm going to put all of those documents into that box, and that's what my trust owns. So it's important not just that you create the document, but then we use the term we fund it. We put stuff into the trust. And that's how a trust is created. We create it and then we fund it. It's two parts. And what we're going to talk about as we go through today is, how do you make sure that as time goes on, 5, 10, 15, 20, even more years after you create that trust, how do you make sure that it's still the right document for you, that it's still the right vehicle for you and your loved ones when things change? Things change within your own family structure, within your own life, and then also externally with the government and laws and taxes, et cetera. And that's what we're talking about today. How do we keep that trust healthy? So we talked about what the trust is. Why does someone create a trust? Someone creates a trust for many different reasons, some of which are to avoid probate. Probate is that process of making your will go through the courts in order to be validated. And often people want to avoid that process. Some people do it because they're trying to save on estate taxes. Maybe they're creating a life insurance trust or some other kind of trust to get assets out of their taxable estate if they have more than the exemption amount, which this year is in New York State, 6.11 million in their estate. And then some people do it for asset protection from Medicaid. So if you are concerned that down the line, you or your spouse are going to need long-term care through the Medicaid program, either home care or nursing home care, you may be looking into protecting some assets in a trust, an irrevocable trust, a specific type of irrevocable trust, so that you can seek care from Medicaid without those assets being either counted when you apply or clawed back at death. I am doing this topic today on keeping your trust healthy, and we did it just a few months ago, I think back in November. And the reason that we're doing it again, and we'll continue to do this, is because it is the number one phone call we get from prior clients are questions about their trust. What can I do? What can't I do? And so I want to talk about the what you can and what you can't of different trusts today, because it's the topic that comes up most often. Because very often people sign these documents and maybe they never fund them. Remember, I said it's a two-step process, or they go through both steps, they fund them, and then they go away and they never even think about it again. And I have people who come in and they say, well, I have a deed and my deed says that my house is owned by a trust, but I have no clue where that document is. I don't know what it says. I don't know anything. And then their next question to me is, can I, and they have a question, can I sell the property? Can I change who the trustees are? Whatever it may be. And my answer is, I can't help you until I find and see that trust document, because that document, again, is going to give me the rules of the game. So let's go through some different types of trusts and some of the potential rules that we see in these trusts. So number one, it's important to note who the trustees are, and whether or not the creator of the trust, we use the term creator, grantor, settlor. These are all words for the person who creates the trust. So who are the trustees, and can the creator of that trust change who the trustees are? These are important things to pay attention. We often put in our trust, who's the trustee when it's first created, who's the trustee once the creator becomes incapacitated, and who's the trustee after the creator is deceased. And that can change throughout the life of the trust, depending on the trust document. When you have a revocable trust, so it can be fully revoked, amended, you can add things to it, you can take things out of it, there are no restrictions on it. When you have a fully revocable trust, the grantor or the creator is usually also the trustee. Sometimes my grantor, my creator, will be co-trustee with their spouse, or co-trustee with an adult child of theirs if it's a little overwhelming for them to be the only trustee of their trust. And that's where your specific circumstance is going to change how you decide to do that. But in a revocable trust, you can be your own trustee. When we're looking to do irrevocable trusts for estate tax purposes or for Medicaid purposes, someone other than the creator or their spouse, well, for Medicaid purposes, their spouse, someone other than the creator must be the trustee. So again, that could be the adult child, it could be a friend, it could be a different family member, it can be anyone, just not the creator. And that is because we can't give the creator too much power over those trust assets, or else it won't have the protections. Once we figure out who the trustees are, we then determine who are the beneficiaries of the trust. So if I create a revocable trust, during my lifetime, I'm a beneficiary. And I would like it to say that I'm a beneficiary of income from trust assets and principal of trust assets, meaning everything in the trust I am the beneficiary of. I might make my spouse also a beneficiary during my lifetime. I may want my children to be beneficiaries during my lifetime. I may want to allow gifting to certain persons or to charities during my lifetime. Then again, we move to my incapacity. Maybe during my incapacity, I don't want there to be gifting to charities, but I do still want to provide for my spouse or my children, but only after I'm sure that my needs are met. Well, I can put that into the trust document. I can say my needs are primary, but these needs are secondary. Then after my death, what happens? Is everything just pay out equally to the beneficiaries and they get a check and they get it outright? Well, then there are no ongoing trustees once the assets are sold and distributed. But perhaps I've left things behind where my spouse, for certain purposes, or my children or my other beneficiaries have a continuing trust that goes on beyond my lifetime to protect them in some manner. And in that case, who's going to be the trustee of that trust? And to what extent is my beneficiary a beneficiary of that trust? So I may make a trust where I say my spouse can get all the income from that trust, but they can't get principal. Or they can get principal, but for limited purposes. Or maybe they can get principal, but only if it's a trustee that's not related by blood or marriage, an independent trustee. So as you can see, when you're creating a trust, there's a lot of different choices here. And I've often referred to it as choose your own adventure. When you're going through a trust document, there's a lot of places where we can stop and say, okay, these are your options. These are the limitations that you can put on your trust, your beneficiary here. And these are the reasons you may want to or not want to put those limitations. How do you feel? And we create the trust document based on those wishes and the general goal of the creator. So again, we want to make sure that it's clear what the beneficiary has access to. They may have only access to income, or maybe only at the trustee's discretion, or we may force all the income to that individual, saying that they must receive the income every year. That can all be written into the document. So I'm going to go through a few of the things that often come up in conversations that we get from a lot of people. I'm going to talk now about what happens when you have property, either your primary residence or maybe a piece of land or secondary residence, real property that's owned by your trust. These are some of the most common questions that we get on that topic. And this is so crucial, especially if you have an irrevocable trust with any kind of limitations, because if you break the rule, even if you do it by mistake because you didn't know any better, you could be ruining all the protections that that trust has. So for example, if I have an irrevocable trust for Medicaid reasons, well, that's going to say that if I'm the creator, I have to name someone else other than myself or my spouse as trustee. I can receive all income, but I can't receive principal. So if I own a house inside of my trust and that house gets sold, then the checks at closing have to be written to the trust and deposited into a trust bank account. Because if that money goes to me as the creator of the trust, I am not a permissible beneficiary of that money. And therefore, I broke the rules of the trust and I lose the protection. So little mistakes, while it seems like, oh, they can be fixed, they can ruin the trust protection. And it's really important to follow the rules properly. So first I'm going to say, can I sell a property that I've put in my trust? Yes, you can sell a piece of property that your trust owns. Just like I said, whoever the trustee of the trust is, if it's a revocable trust and I'm my own trustee, or if it's an irrevocable trust and I have a different trustee, that trustee, whoever it is the one that needs to sign the agreement with the realtor to sell the property. They sign the contract with the buyers, and they are present at closing to sign off on the sale. So you can sell a property in trust, and it is the trustee's job to carry out those functions. Now, I will point out that if you have the right to change the trustees of the trust and you don't like what your trustee is doing, you can change your trustee so that your trustee sells when you want them to, sells to whom you want them to, for what price, etc. So there's certain controls you can have, even though you can't have any use or enjoyment of those funds. Does my trustee need to be involved in the sale? So yes, again, the trustee is the one who's in charge of signing the listing agreement, the contract of sale, and being present at the closing to sign off on the sale of the property. What do you do with the proceeds? Like I said, the proceeds of the sale are deposited into a trust bank account. Now, what you do with them from that point is up to the trustee of the trust and up to whatever the rules of the trust say. So if it's a revocable trust and I'm my own trustee and I deposit the proceeds into the trust, I can use them however I want, as long as that trust document doesn't limit me. And in a revocable trust, it should not. However, if I have the irrevocable trust, again, let's say the one for Medicaid protections, again, that trustee takes the check, deposits it into a trust bank account, and then they can buy another property. They can invest the money in stocks or some other asset. They can leave it in cash. Any mixture of things, all within the trust. They just can't give me the money from that sale because I'm not entitled to it under the terms of the trust document. But we very often have clients who sell the big house and downsize and get a condo or a co-op or something smaller, more manageable. Well, the property can be sold and that money used to purchase something smaller. Now realize though that any if there are maintenance fees because it's a co-op or a condo, or any housing fees for a housing association, HOA fees, those cannot be paid by the trust if it's an irrevocable trust for Medicaid reasons, because that's basically the trust paying my way and I can't have the trust benefit me. So the trust can buy me the property, but I have to be responsible to continue to pay for any upkeep or maintenance or costs of the property. So again, the terms of the document are going to control. So as you saw in all those examples with the property, it's really going to depend on what that trust document says to say what we can do with that money once the house is sold. But what we find is, again, we get a lot of phone calls from people who have trusts about what the trust can do in terms of sale and what to do with the money afterwards. It's always better to seek the advice of your attorney, of your estate planning attorney before sale, because if your real estate attorney, they may not be familiar with trusts and with how they work. And therefore you want to make sure that the closing, that there isn't some check cut or some action taken that puts in jeopardy the protections that we have around your trust. It's very important to have your estate planning reviewed. So like I said, certainly if you're going to be selling a property, you want to check in with your lawyer to see what has to be done. We tell everybody every 3 to 5 years, you should have your estate planning reviewed. Even if it's just a check-in to say, do I need to fix anything or do I need to change anything? But in addition to every 3 to 5 years, if there's a major change in law that you think might affect your circumstance, if there's a change in life situation, so maybe you are selling your house, maybe you're retiring, maybe you are moving out of the state, maybe you had a few more grandchildren, the loss of a family member, all of these things are changes that may affect what you want to do with your trust. And if changes are possible, if you have certain controls over your trust, you may want to exercise them at that time. You may just have a change in preference. You may have named one trustee who was your child that lived around the corner, but now they've moved across the country and it would be easier and make you feel more comfortable to have a different child service trustee because they live closer. You can do that. You can, if the trust gives you the power to do so. You want to make sure that your trust protects that child and their inheritance when you do pass away. Maybe you have a beneficiary that you helped buy a property. Maybe you helped your daughter buy a house, and so you want to change the beneficiaries of your trust to reflect that upon your death, your son get an equal gift to what you gave to your daughter to purchase her house. All of these things are changes you can make as long as the power has been reserved by you to make those changes in your document. Keep up with your Schedule A. So people ask me all the time, what's the Schedule A? Schedule A is a piece of paper that says Schedule A at the top, and it lists what your trust owns. The day you sign your trust, you'll notice it usually will just say $10 cash, because a trust doesn't own anything until we take that second step of funding it. And when you fund it with assets, when you put things into the trust, we keep a list on the Schedule A. The Schedule A is not binding. I'm going to say that again. The Schedule A is not binding. So if I own my primary residence and a second piece of land, it is not enough to just write the addresses on the Schedule A. I have to do a deed for each property that gives the property to my trust. Best practices are that once you sign that deed, you list that property on the Schedule A. If you then sell the property and it's not owned by the trust anymore because it's been sold, you can cross it out. Maybe you want to make a note next to it, sold, and put the date. Whatever it is that is your record keeping to say what happened with the trust, so that when a successor trustee takes over, if necessary, they have all the background information right there on the Schedule A. They'll probably have to back it up with deeds and bank account statements and things like that, but it is a cue to them and a clue as to how to move forward. And so keeping up with that Schedule A is really important. You also want to make sure that your beneficiary designations stay current. So there may be certain assets that you have decided not to put into the name of your trust, that your trust doesn't own while you're alive, but you've named the trust as beneficiary of that asset upon your death. If that's the case, you want to continually check in to make sure that those beneficiary designations are on file. Say your brokerage account is, the ownership is in your trust, well, then you don't have to worry so much about the designations. But if you've left your brokerage account outside of the trust for some reason, you would want to transfer on death form showing that the trust becomes the owner upon your death so that it can be dealt with by your trustee. But you want to make sure that that's up to date. Certainly if the bank changes, or again, every 3 to 5 years, just check in, who's listed as my beneficiary, is it still correct? Certainly, if you purchase a new asset, you're going to want to add that to the Schedule A and add it to the trust. Sometimes I have clients, we do all this work, we create trusts, we put all their assets in the trusts, and then 10 years later, they come back and they say, oh, we bought 2 additional properties, but we didn't put them in the trust. They're outside of the trust. Well, that defeated probably the purpose of why we created the trust. So if you are going to be purchasing a new asset, you should be checking in with your attorney to see, should this asset be owned by my trust? Or is there something I should be doing with this asset other than just holding it in my sole name? And that's going to depend on your specific estate plan. The other thing that we've been looking into doing more often is creating a trust protector on a trust. This is most relevant for trusts that are a trust for one individual's lifetime and then will continue past their lifetime and be a trust for others. That way, if I create a revocable trust and upon my death, it becomes irrevocable, and down the line, there's changes in law or other changes that make it that we need the document to be adjusted for the benefit of those that I've left things behind for. A trust protector can be put into the document, and that's someone totally independent from you, not related to you at all. If they are in there as a totally independent person as the trust protector, they can make certain changes to the document if called upon to do so. And so that's something that you may want to look into getting in your trust if you're concerned that this trust is going to last beyond your lifetime and changes might be necessary. I'm going to stop now and answer. I see some questions have come in, so we can go and answer those.
The first question is, let's see here. In order to sell the house, do all 5 children have to agree on the particulars such as price to sell or not to sell? If the agreement can't be completed, does majority of children rule, or does trustee have a final say?
Okay, so that one says mom has a trust with the house and the names of her 5 children. So I'm going to assume that this individual owned a property, gave it to her 5 children, and reserved a life estate for herself, because that's likely what I'm assuming this means. So that means that while mom is alive, it's mom's house. She pays all the taxes, all the expenses. But the second that she dies, that house belongs to the 5 children. We don't generally like to do this. This is a prime example with 5 children of why we like trusts better. I would have preferred that mom, instead of transferring the deed and reserving a life estate, I would have preferred mom to transfer the deed to a trust. The trust say what should happen, and then the assets be distributed. Because yes, all 5 of these children, if it's a deed with a life estate, are the owners of this property after mom dies. And so if it's sold mom after mom's death, certainly, or even while mom's alive, they will all need to agree. And if they can't agree, it is not the majority rules, because they all have to sign off at the closing. They all own an equal share. There could end up being a court case to force what we call a partition to make them sell. So this is not a preferred way of owning property, especially with 5 children. My preference would have been for mom to transfer that property to a trust, and maybe even go as far as to name 1 or 2 of the children as trustees and give them the authority to sell. And it's only once they sell it and they get the money that they divide the money 5 ways. That's probably going to be an easier thing to do rather than have 5 cooks in the kitchen on that one.
Thank you, Britt. Next question. What types of things can you put into your trust to fund it?
So anything you own. So, I spoke about a property with a deed. If the co-op allows it, you can put a co-op in. So your stock shares and your proprietary lease into the name of your trust. Bank accounts. So brokerage, stocks, bonds, regular checking and savings. You will not put tax deferred retirement into your trust. So while you're alive, if you have an IRA, a 401k, a 403b, teacher's retirement system plan, TDA, all of these things will not go into your trust. Only in certain circumstances will your trust be named perhaps as beneficiary, but that's a very specific situation where we do that. So you should speak to your attorney if you're worried about that. But we also put your personal belongings. So we very often sign what's called an assignment of personal property when we sign a trust. And I explain to people as wave a magic wand around your house. Everything you own now belongs to your trust. My earrings, my jacket, my furniture, my silverware, all of my belongings that don't have a title, that don't have ownership that can be given like a deed. You can use an assignment of personal property. And we often put LLC shares into a trust, S Corp, if you own a company. So you can really put anything that you own in your name, you can put into the name of your trust.
Thank you. Next question. Does the trust revocable become the beneficiary on bank accounts? Currently, our non-trust accounts, our children are listed as beneficiaries.
So I don't have a straight answer for that one because it will depend on the circumstance. Every client that I sit down with, once we create their trust, well, before and after, we go through a full list of every single asset they own, life insurance policies, checking, savings, everything. And one by one, we determine if it makes sense for it to be owned in their names or in the trust. And if owned in their individual names, if the beneficiary should be the individual persons or the trust. And it's going to depend on your children's situation, your wish for how those assets are distributed at your death, the who the trustees of the trust are. All of that is going to go into it. So if it's a revocable trust and there might be some assets that you're comfortable going to your children outright, it's going to depend. You certainly can name your children individually if it accomplishes your goals.
Thank you. Next question. If trustees use funds in trust to purchase a property for grantor, can those funds later be replenished in trust without affecting the 5-year look back?
Okay, I'm going to try and understand that question. I think what this individual is saying, and I'll answer it this way, and if they want to write in and clarify, they can. So if the trust has money in it, and then the trust purchases a property, and the grantor lives in that property, the 5-year look back for Medicaid was relevant from when those funds first went into the property. So grantor has $500,000. Grantor transfers assets into a trust. Regardless of what happens in the future with that money, as long as it stays in the trust, 5 years after grantor put that $500,000 in the trust, it is outside of any look back for nursing home Medicaid. And so in that person's case, even if that money was subsequently used to purchase a property the grantor is living in, as long as the grantor is paying the taxes and all of the fees of the property, that is still okay. And that transfer that was effective when the money first went into the trust.
Thank you, Britt. Next questions. If brokerage account has beneficiaries, does brokerage account need to put into the trust?
If brokerage account has beneficiaries, it depends what type of trust you have and what goal you're trying to accomplish. So if you have a $200,000 brokerage account and your goal is that it goes outright to your beneficiaries at your death, that's fine. If you are looking for asset protection for Medicaid purposes over that money, then yes, it would have to go into your irrevocable trust in order to have that protection. If that's your only asset and you have a house that has to be maintained until it's sold at your death, you might want to make sure you have bank accounts in the trust to support that house until it's sold. So again, this is going to be a very person-specific conversation. So it's not necessarily wrong to have beneficiaries. You just want to think through in your circumstance if it's going to accomplish your goals.
Thank you. Next question, please define and explain a slat.
Right. So a slat is an estate tax planning tool. Again, in New York State, if you have less than $6.11 million, you do not have a taxable estate. There will be no estate taxes due at your death. Federally, the current exemption is over 12 million per person. However, in 2026, that will go back down to around 6 million. A slat is a spousal lifetime access trust. And the idea is that if I am creating a slat, I'm creating a trust where I'm trying to get assets out of my name so that they're not taxable in my estate, give them to a trust where my spouse has access to that trust and my spouse can use that money. And there's certain powers that I can give my spouse or not give my spouse, and certain things that I can put into the trust to change what happens with it in the future. But the idea of a slat is to move assets out of my taxable estate, but have my spouse have access and use of those assets. We were doing a lot of slats last year when people thought that it was over 11 million exemption federally last year. People thought the exemption is going to go away. It's going to go down sooner than 2026. And we need to get assets out of our estate while the exemption is really high and file a gift tax return. So people were doing slats because they thought that that was going to be the case. Now, we didn't have that change in law that we were anticipating or fearing or waiting for. So it became less of a rush. So anyone who did a slat last year should certainly be looking at it. But we really only recommend slats for marriages where they're more long-term marriages, because you're giving up control of your assets and giving it to your spouse. So there really has to be a lot of trust between the two individuals.
Thank you. Next question. Irrevocable trust set up with bulk of money. Grantor kept some cash money, not in trust. How does this cash money affect the Medicaid look back?
So if you take all your assets and you put them in a trust, but you leave $80,000 in your name, and it comes time that you have to apply for Medicaid, if you're applying for home care Medicaid, currently today, February 2022, there is no look back for home care Medicaid. So we would take all of that 80,000 that's above your allowable limit, which this year is 16,800, and we would move it out of your name, either to the trust or, depending on your circumstance, what we would do with it. And you could qualify for community Medicaid, home care Medicaid in the following month. If you were looking for nursing home Medicaid, so Medicaid to cover the cost of long-term nursing home care, that has a 5-year look back. So if all of your other assets have been in the trust for 5 years, then none of that is in the look back, because remember, the look back is saying you need nursing home now. I'm going back 5 years. What did you give away in the last 5 years? So if you didn't give anything away because you put everything in the trust 6 years ago, everything in the trust is safe. The assets that are still in your individual name, then at that point, there'll have to be a plan to figure out, what do we do with this excess money? Approximately $65,000 in my example. What do we do with that $65,000? We might prepay for your funeral services. We may give some of the money to the facility because we do certain planning where you pay a little bit and then you go on Medicaid and we try and save a little bit of the money. But anything that was in the trust will be protected if it went in more than 5 years prior.
Thank you. Next question. If you have an irrevocable trust for your home and another property, can you swap one of them out to be replaced by a bank account for less, or is better to just add the bank account?
So that's a good question. So when you create that was an irrevocable trust. Okay.
Irrevocable.
So when you create an irrevocable trust, my first answer on all of these is it depends what the trust document says. So there's something called the power of substitution. And we often and many times put the power of substitution in our trusts. So what that power says, and this is actually right out of the IRS code, is if you have assets of equivalent value, and in this person's example, house in the trust, cash outside the trust, if they are of equivalent value, you can swap them. So then your house goes out of the trust and your cash goes into the trust. But you can't do that. In this question, this person asks if it's lesser value, you can't. You have to swap assets of equivalent value for it to be allowed. But again, only if your trust document specifically allows for it. So if you have a house that's worth $800,000 and a bank account that's worth $300,000, then it might just be that you take that bank account and put it in the name of the trust. And again, it's going to depend on the circumstance, but you wouldn't be able to swap unless they were of equivalent value.
Thank you. Next question. If I put together a revocable trust 10 years ago and my wife and I sign a new revocable trust this year, does the new revocable trust automatically supersede the older revocable trust?
So not necessarily, unless you've done a restatement of trust. So you can think of it as if you created, this is often confusing for people because with a will, I always say every will you sign is your last will and testament, because all wills revoke the prior will. It is not the same with a trust. With a trust, if you signed a trust 10 years ago, and then now you're signing a new trust now, it's just, you have two trusts now. And so it's almost like you had a child 10 years ago and now you had another child. You didn't replace your first child, you still have two. The question is, did you do a restatement of trust this year or did you create a new entity? So if you restated your trust, it would actually say at the beginning, I originally signed a trust 10 years ago. It was called this, and now I'm restating the terms of that trust. And this is the restatement date. Well, then you still just have one trust and that new document superseded the old document. But if you just created a whole new trust, you now just have two trusts. And there's some reasons to do that or not to do that, depending on the circumstance.
Thank you. Next question. Look back question. Using your example, my question would be, if a property is purchased by the trust using the $500,000 that was put in the trust as at its creation, could the $500,000 be later replenished in the trust without affecting a 5-year look back? Or would we be better establishing a new trust for the new assets?
So no, it's not a replenishment. If 500 went into the trust and the trustee chose to buy a house, that's still the same asset. Any addition later of another set of 500,000, another influx, would be a new transfer. And whether or not you would create a new trust or add that money to the old trust would depend on the circumstance, and what the decision would be made with your attorney at that time. But it would be seen as a new transfer of $500,000.
Thank you. Is it a good idea to have the trust be a beneficiary of a brokerage account?
Sometimes. It really depends on the circumstance. So it's going to depend on your circumstance, what type of trust and what your goals are, and the situation of your beneficiaries. Like, for example, there are a lot of reasons that would go into it one way or the other, but one example is if you have 10 beneficiaries, you would probably like your trust to distribute that brokerage account at your death, rather than just name the 10 individuals separately, because it would be easier for your trustee to collect that money, make sure any debts and expenses of your estate are paid, and to then give everything out properly, than for there to be 10 different people that have to contact a bank to get that money. But in certain circumstances, you may have that your beneficiary and your trustee are the same person, and there might not be any continuing trust. And so that might be perfectly fine to just leave it outside of the trust. So it's going to depend on your circumstance.
Thank you. Could you clarify the benefit of a revocable trust versus an irrevocable trust?
Sure. So both types, revocable and irrevocable, avoid probate. They avoid that court process at your death that invites people to come in and contest, and that can add delay and expense and process to your final wishes being carried out. The difference between revocable and irrevocable is that in revocable, you're really only avoiding probate. You're not doing anything else. You're not achieving any other goals. You're putting, maybe the only other goal would be administratively putting everything under one umbrella, but you're doing a revocable trust to avoid probate. An irrevocable trust is a trust that has, and there's many types of irrevocable trusts, but they have restrictions on the creator of the trust in order to create some type of protection. So one type of irrevocable trust is a irrevocable life insurance trust. The goal there is to take a life insurance policy and remove it from your taxable estate so that it doesn't grow your estate taxes if you have a taxable estate over the 6.11 million. That's one type of irrevocable trust. And therefore you don't have access to that policy. You can't take a loan from the policy. You lose certain access in order to gain a certain benefit. And that's what an irrevocable trust does. Medicaid asset protection, that's a type of irrevocable trust. You can keep the power to change the beneficiaries, change the trustees, you can get all the income, but you can't have access to principal, and principal can't be used for your benefit. And that's your give and take on the irrevocable trust for Medicaid purposes. There's certain trusts that we create, not for life insurance, for other assets, to remove those from your taxable estate. But again, you would lose the access and the ability to control those assets by giving them up. You're getting the power of getting them out of your estate. And so those are the pros and cons of an irrevocable trust. It's a give and take. You don't get anything for nothing. If you want certain types of protections, you have to give up certain types of powers.
Thank you. All cash irrevocable trust has been in effect more than 5 years. Is there any way Grantor can get some money out of the trust if needed? So
it depends on the terms of the document. Sometimes there are lifetime beneficiaries of trust principal. This can't be the grantor if this is an irrevocable trust, especially not if it's one for Medicaid asset protection purposes. So sometimes it's the children of the grantor, sometimes it's some other person. So if that provision is in there, then there might be a way, but you'd have to look to the trust document to see. But that can't go to the grantor, that can go to some other individual. There is a way that you can revoke irrevocable trusts, but we have a lot of information that the Medicaid program, Department of Social Services, the individuals who are reviewing trusts and and people's access to them frown upon and often say that the trust no longer has protections if an irrevocable trust is revoked in part to give some of the money back to the grantor. So our advice to individuals is that if you're putting assets into an irrevocable trust, your goal should be that that money is to be put aside and not used except for the income that it generates. And for everybody who's going to drop off, thank you so much for joining us. I hope this was informative. And like I said, we will keep talking about keeping your trust healthy because there's no point in doing it if the rules don't continue to get followed for the rest of your life.